Good afternoon. Welcome to Division 2 of the Colorado Court of Appeals. We have two cases on our 1:30 docket. But before I begin that, I wanted to tell you that I'm John Daly. To my right is Judge Nancy Lichtenstein. To my left is Judge Karen Ashby. We'll be presiding judges this afternoon on these two cases as well as a 2:30 case. On the 1:30 docket, we have Boulder and White Rock Ditch Reservoir Company versus O'Toole et al. Counsel are here and prepared to proceed, I take it?
Yes.
Your Honor. Yes, sir. Second case, Deborah Garrett versus Credit Bureau of Carbon County. Are the attorneys here and prepared to proceed?
We are, Your Honor. Yes, Your Honor.
Thank you very much. I appreciate it. When you came in, you should have received some oral argument instructions from the bailiff. Did you receive those instructions?
Did I, Your Honor?
Did you receive those instructions?
Yes.
Yes.
Yes, Your Honor.
Yes. Did you receive those instructions?
Yes, sir. Yes, Your Honor.
Okay. Did you have a chance to read them? I take it the answer is yes?
Yes.
That's all right. Thank you. You remain seated. Do you have any questions about those instructions?
No, Your Honor.
Okay. I just want to remind you that our oral arguments are being live streamed and they're also being archived on our state judicial website. Please don't give any confidential or sensitive information for a case later in the day, not to mention names of minors. Also, when you come to the podium, please give us your name and your attorney registration number. And last but not least, please, everyone in the audience, turn off your cell phones and pagers so as not to disrupt the oral arguments in this matter. With that, I think we can begin the arguments in Boulder and White Rock Ditch and Reservoir Company versus O'Toole. And let me say before you begin, I'm going to give each side 20 minutes because there's an appeal and a cross appeal. And I take it you represent the O'Tooles and the neighbors? Okay. So you'll have 20 minutes total to address all the issues on the appeal and cross appeal. You can save rebuttal if you want. There won't be any rebuttal for the appellee and cross appellants. So 20 minutes each side.
Good afternoon. May it please the court. My name is Joel McGuire, registration number 9073, and I represent the defendants, appellants, and cross appellees, Niall O'Toole, Marianne Carroll, Thomas McWilliams, and Renala Condominium Association, and I've referred to them in the briefs as neighbors. In this case, as you pointed out, Your Honor, involves both an appeal and a cross appeal, and initially I'm going to address the issues on appeal, and those relate to the district court's decision granting summary judgment in favor of the ditch company under its claim under CRS 38-41-108, and the district court's denial of my client's request that it recognize their right to an easement for the historic footpath that allows access to and from their properties.
Counsel, could I reorder your arguments because I think there's a serious question about standing on the part of your clients to contest the title in this case. And your opposing counsel has cited in the reply brief and as well as supplemental authorities indicating that defendants in a quiet title action need to have a claim of title themselves. Did your clients have a claim of title themselves, and in what way?
Well, Mr. McWilliams, who was represented by other counsel at the time, and his counsel is deceased now, but he did assert a claim to title in his answer. My clients did not assert a claim to fee title in the answer. They asserted in affidavits in response to summary judgment briefs that they had an interest, that is a right or an easement over the property, and that was submitted not only to refute the ditch company's claim to adverse possession, showing that they did not prevent my clients from accessing their properties or using the footpath and whatnot, but it just showed their right. They had an interest in the property, but they did not claim a fee interest. Now, the standing issue was raised at the outset by by Ditch Company's counsel on a couple of occasions, I believe. And he claimed, even though he named my clients as defendants in the suit, that they did not have a right to defend the suit because he said they didn't have standing. But based on the research I located and in the briefs I cited to the trial court, a defendant does not have to show standing. The fact that they've been sued puts them in front of the court, and that's all they need to come in and argue that the plaintiff is not entitled to the relief the plaintiff is seeking. But also under traditional standing standards, they have standing, as I argued in the trial court, because they were neighbors, they had an interest in the property that was next to them. They didn't want, they were concerned about their property values,
The more specific case law cited by the opponents, in this case, suggests that you need more than an interest in property values or falling property values. It suggests you need some type of property interest in the subject property itself. And those cases seem a little bit more specific than, say, the cases about if you're a defendant, you don't need to have traditional standing. More specific to the quiet title arena.
I'm not positive the research you're referring to, the authority, but I know that they claim that, in fact, actually I'll refer back to the trial court. One of the things that the trial court said was that my clients, the defendants, because they could not show a superior title, that this basically opened the door and shut the door in favor of the Ditch Company, because the Ditch Company comes in, made a claim, even though we think that they didn't satisfy any of the elements under that statutory provision, that the fact that they made the claim and my clients could not come in and claim a superior right, that basically shut my clients out and mandated a finding in favor of the Ditch Company. Now, there's cases, the Hudson case I know is one, that says that the plaintiff in a quiet title action cannot just rely on the weakness of the defendant's title, that they have to prove under, in this case, 3841-108, that they have satisfied the requirements for relief under that statute. They have to rely on the strength of their own title. And in this case, that makes sense because under our view of the facts, and I think they're undisputed, they have not satisfied any of the elements of that 3841-108. So it makes no sense to me, just from a, I guess, logical standpoint, that they can come in, present no evidence, and yet prevail just because the defendants who they've sued do not have a superior claim to title. They've got to prove the elements of that statute. So for that reason, and the judge ruled in our favor on the standing issue, obviously, but I think for any number of reasons, I think my clients have a right to come in and fight this claim. So then I was going to say the other issue, of course, is well, no, I got to that point about the request for an easement in case the trial court's ruling on summary judgment is affirmed. So let me talk about that first decision. The Ditch Company was awarded fee title to the ditch property, which everybody has referred to as Parcel 2, even though one, the 1914 deed from the predecessor to the Ditch Company conveyed only the rights of the predecessor under the 1874 deed right-of-way documents, and even though the 1874 deed right-of-way documents do not purport to convey fee title under the usual rules of construction, okay? Also, the judge found for summary judgment in favor of the Ditch Company, even though there was no evidence, in fact, no allegation, that the Ditch Company ever did anything on that property in the 125 or so years, more than that it had its easement. It never did anything on that property other than what it was permitted to do under those right-of-way documents, namely to build and maintain and operate its ditch.
Didn't the trial court say that there was color of title because the 1914 deed purported to convey title without limitation? What
it sa-
language is there of limitation is there in the deeds?
What it said, Your Honor, that it did rely for its finding of color of title on the 1914 deed from the ditch company's predecessor to the ditch company. That 1914 deed conveys the predecessor's rights to Lot 5, and that it had fee title in Lot 5, I believe Lot 7, and then it says also the right-of-way under the below listed documents, and it listed the recording information for a bunch of different, presumably easements, two of which are the Leonard deed right-of-way document and the McCammon deed right-of-way document. And it says those are incorporated by reference into the deed. Now, what the judge did here is she didn't analyze the 1874 documents, because my position is, look, if all the ditch company received it was the predecessor's rights under the 1874 documents, you have to look at the 1874 documents to decide whether those provided color of title. You have to examine those, the language of those, use your rules of construction to determine whether or not that language provided an easement or fee title. But what the judge did was say, look, I'm not going to analyze, I mean, she didn't say I'm not going to analyze, but she didn't analyze the language. What she said is there's a reverter clause in these documents. And she cited a case, this Barnes case, which I believe she's misinterpreted for the reasons stated in my brief, to say that when you have a reverter clause, it automatically means that the document is a fee simple determinable. In other words, if the reversion says that the person who got the conveyance ceases to use the property for the purpose stated, then it reverts. And she said this means it reverts to a fee, therefore the 1874 documents conveyed a fee. And what I'm saying is no. What you look at is all it means is it reverts to what it was before. If it was a fee, it reverts to a fee. If an easement was granted, that just means that the failure to use the property as intended means that the use granted by that easement returns to the owner. So that was my understanding of the basis for her finding of color of title.
So, Mr. McGuire, do you agree that it was a fee simple determinable, or do
No.
you disagree with that?
I disagree with that, because a fee simple determinable, obviously, I mean, it's similar to an easement with a reverter clause, because in both instances it says the conveyance is conditioned upon the use of the property in the manner stated. So if the person gets an easement, they fail to use the property as intended and stated, then they lose that right. That use reverts to the owner of the property. If it's a fee, the fee is transferred, but the fee comes back if the property is not used as intended. So it is not a fee simple determinable. It's an easement with a reverter clause.
So why is it an easement with a reverter clause as opposed to a fee simple determinable with a reverter clause?
Because you look at the language of the everything starts with these 1874 deeds. Because what they are claiming is that instead of an easement, even though it says deed right-of-way, even it refers to right-of-way for a ditch, blah, 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 they're saying that actually the intention, and this is you have to go back and find out what was intended. Did the parties intend transfer of a fee, or was it an easement? And so you look at the 1874 documents, and under the rules of construction, there's several reasons why those were easements. I mean, you look.
Did the McCammons ever make any use, or Leonards make any use of that property over which this easement had been given?
From the actual ditch property, so to speak? I don't know. There's no evidence of that. I mean,
Do you have a case cited in your brief saying there's an easement with a reverter as opposed to a fee simple determinable with a reverter?
you mean, is there a type of animal like that?
Do you have a case in your brief cited where it says this is, and here's a case that supports this, that this is an easement with a reverter?
Well,
Is that a yes or no?
Yeah,
Okay.
it is a yes. And the reason why it's in there is because when I argued that the judge erred in saying that this was a fee simple determinable based on solely on the existence of the reverter clause, the ditch company's brief came back and it says, well, you can't have a reverter clause in an easement. And so I cited, I think, 4 or 5 cases in the reply brief where that kind of instrument was discussed in a case where there was an easement with a reverter clause. So there is that type of legal
And you cited
instrument.
them to us.
It's in the reply brief.
And let me ask you this, does it matter whether it's a fee simple determinable with a reverter or an easement with a reverter if the 1914 deed didn't pass anything but something with a reverter?
Well, yes, it matters because the underlying question is what was conveyed to the ditch company with that 1914 deed, because that's what they're relying and saying on, saying that this deed provided color of title. Maybe it wasn't clear as day, but they're saying it provided color of title because it was intended to convey title. So you have to go to the underlying document.
See, I construed their briefs to argue that it's the 1914 deed that provided the color of title. It's the 1914 deed, as the judge said, without limitation, that purported to say, we don't have to worry about reverters.
Well, I don't know whether the judge said, maybe your memory's better than mine
No,
on
this is a paraphrase.
Okay, she relied on the 1914 deed. They relied on the 1914 deed. But I'm saying that it itself cannot provide color of title because it references the underlying deeds, which you have to look at to decide whether those deeds provide color of title. All the 1914 deed, it says, from predecessor to ditch company, it says, here, you have what we have now. That doesn't provide color of title. It expressly references these 1874 deeds, so you have to look at those to decide what exactly the predecessor was conveying to the ditch company. But back to the question about the meaning of the language in the 1874 deeds, I said the title says deed right of way, okay? And there's, under the rules of construction, let me find it here, there's a lack of specific description of the property. The law is that if you don't have a specific description, it's much more likely, if not mandated, that it's an easement, not a fee, because obviously you need to know exactly what you're conveying to have clear title for future generations. And the ditch company has itself reported, quote, the 1914 deed is drafted in such a general manner that all title companies approached by plaintiff have denied plaintiff's request for title commitment. I mean, that's an indication that it's not specific enough to even get title insurance on it. The granting clause, that I've cited a couple of Texas cases that say that if the grant of the right-of-way is before the description of the land, then that's an easement. If the land is described first and then said it's for a right-of-way, that is a fee. Here, the right-of-way appears before the description of the land.
Is the case law uniform on that throughout the country?
I didn't find anything else. I mean, there's the Texas Court of Appeals cited this is a 2017 case. They cited a 1952 Texas Supreme Court case. They said in the opinion that the Texas Supreme Court case wanted to resolve a split among the divisions in Texas, apparently. I didn't find anything else. Okay. The 1874 deeds grant a right to build a ditch. If it's a fee grant, you don't need to grant a right to build a ditch. I mean, they can do what they want out there. You can say it has to be used for ditch property, but they granted a right to build a ditch. And they also reserved, under the McCammon deed, it reserved a right to McCammon to use the property for whatever they wanted to do to the extent it didn't conflict with the operation of the ditch. Well, I mean, if McCammon could do anything on the property, I mean, that's, if it was a fee, you'd think that they would have specified exactly what McCammon could do so that it would at least clear things up for future if they wanted to sell the property. So I think the existence of that reservation in there also indicates it's a easement, not a fee.
I would suggest that, gee, you can do anything you want except this, suggests that it could be a fee simple determinable except this. Let me ask you this, counsel, because your time is getting short. Let's assume for a moment that we were to agree with your appeal as well as your defense of the cross appeal. What relief would be granted in that instance? Obviously, the summary judgment would be vacated. The case would be remanded for what? Is there any other issues to be decided? I know you wanted to ask about the counterclaim. Okay.
Well, what I asked for in the brief, and I believe that you're empowered to do this, is because the evidence is documentary or it's undisputed, that you can rule as a matter of law that the ditch company has not satisfied the elements of 3841-108 and therefore remand it to the trial court to dismiss their complaint.
To dismiss their complaint.
Dismiss their
That is
complaint.
relief that you think is appropriate.
I think it's appropriate under the record because we didn't have any testimony. The facts surrounding this are hundreds of years old. And so under that state of the record, I think you can do that. Now, alternatively, if you want to give the trial court another shot at reaching a decision and having them consider the language of the deeds, the 1874 deeds, to whether or not that actually conveys an easement versus a fee, and tell the court the existence of a reverter clause does not automatically mean it's a fee simple determinable, those things that I raised, then I suppose you could send it back down and say, you need to reconsider your ruling in light of these legal rulings we've made. But one of those two is what we're asking for here. I only have 35 seconds to go, and I think I've covered most of what I want to do. So thank you.
Thank you, counsel.
May it please the court. My name is Edward Bendelow, registration number 1883. I want to begin, I'm going to talk about two subjects, standing and the operative documents. In regard to standing, I filed suit against 40 people. Of those 40 people, and that was based on litigation guarantee, of those 40 people, 36 defaulted. Several disclaimed any interest, including the lender of Mr. O'Toole. No one in those 40 folks claimed any interest in the property, with one exception. Mr. O'Toole and those related folks admitted that they did not have any right, title, or interest in the subject property, and we've cited that in the brief at page 16 of the reply brief. The one exception was Mr. McWilliams, which counsel referred to. He initially made a claim for it, but he presented no evidence to support it, and the district court determined that McWilliams did not have any interest in the property.
Where in the record did the district court determine that?
Page 377. Now, as Your Honor, the question you raised earlier, a standard in one of these matters is whether a party will be injured, in fact, by the actions, or whether the injury is to a legally protected right. The parties who are not making a claim to property simply cannot object to somebody else's claim to that same property. A defendant in a lawsuit to quiet title cannot question the right of plaintiff unless he can show title in himself.
Counsel, you cited these authorities in your reply brief?
I did, and I did it twice by mistake. The supplemental authority I sent last week, we had already covered, and that's in the pages. I'm reading from page 16 of the
Right,
brief.
but not in your opening brief.
That's correct, Judge. All right, so we have this scenario where no one has claimed an interest in the property, but the ditch company. And they have been there for 125 years.
Mr. Bendelow, is it enough to claim a right-of-way, an easement?
Let me address that in a broader sense, because in the I was going to turn to the 1874 deeds. In those deeds, there's a reference to a right-of-way. In the general law, and there are 4 cases cited by appellees, that kind of an interest is deemed to be an easement. Except what was not noted in those cases, and counsel referred to it just a minute ago, is the Barnes case. And in that case, the court determined if there was a reverter. And to Your Honor's comment earlier, it's a fee simple determinable. And accordingly, in the Barnes case, the court says, the conveyance of right-of-way constituted a fee simple determinable. It then found that the railroad's subsequent abandonment of the track provided plaintiffs with color of title by reason of the reverter clause. Here, in the 1874 deeds, they have reverter clauses. From the Barnes case, it suggests that the interest is a fee simple determinable.
Which is different from a fee simple absolute.
Yes, Judge.
I'm sorry, Judge.
No, so I was just going to say, is your position then that if there is a reverter clause, then it has to be a fee simple determinable?
That it is a fee interest, not an easement interest.
Okay.
Reverter refers to conveyance of title. If it was an easement, it would be terminated. You don't have a, anyway, I just explained it. In
Okay.
the case of a fee interest, it's a reverter, okay? All right, so let me then turn more generally to the 6 documents which constitute our claim. There's the 2 1874 deeds, and I would recommend to Your Honors that you would read the language of it, because there's more in those documents than just the right-of-way, railroad right-of-way, ditch company right-of-way. There's also a reference in there to the right of somebody else to occupy, and occupy is clearly an easement. There's, in the other one, there's a reference to a railroad right-of-way, and that this interest being conveyed and sold doesn't preclude the railroad right-of-way. So there's a discussion in those documents that is beyond just the straight language, if you will, the typical railroad, the typical right-of-way kind of language. Turning to the 1914 deed, before I get there. In 1901 and 1906, there's plat of the area. And the plat specifically excludes the ditch company from the platted property, and the name of the ditch company is on the plat showing where the ditch is.
Let me ask you this, does a plat work a conveyance? Is a plat an instrument of conveyance?
First part of the answer is I don't know. Second part of the answer is I don't think so.
Thank you for your candor.
Okay. So those 2 documents, those plats, specifically, if you will, exempt the ditch company from the platted property. Then we come to the 1914 deed, which Your Honor asked questions about. It conveys whatever interest the one ditch company had to the other. With all of its benefits and with all of its faults, it was conveyed. And there is no exception, there's no reverter, it is conveyed. So the parties at the time, acting in good faith, believing that they had title, conveyed it from one related entity to another.
Counsel, let me ask you about that, because the 1914 deed does reference the limitations of the McCammon and Leonard deeds when it says volume 5, pages 523, volume 5, page 524. And in the record, there's an indication that the McCammon deed shows up at book 5, and there's a 523 on the page, and the Leonard deed shows up at book 5, and there's a indication of 524 on that page. So why doesn't it incorporate by reference the limitations of those deeds?
I think it does, Your Honor, in fairness. I agree with you, those are the correct sites to it. But as I said, sometimes it's conveyed with the imperfections that it has, but it is a deed. Here's the whole bundle of sticks, everything that we've got. To counsel's comment about the legal description, it is a very large legal description, essentially gives a legal description from Broadway and 12th all the way out. So the title company struggled with the fact that it doesn't say specifically this, although it's within this. And further to the issue of good faith is the 1964 deed. In 1964, the ditch company, believing that it owned the property, conveyed Lot 5 and retained the right of access, retained right-of-way to get to the ditch, but it, again, reasonably believing that it had title to the property, conveyed a property in 1964. So my point being, an element of the statute is the good faith belief of the parties. Then, where this whole scenario brought us to today, is that the ditch company hired an appraiser to determine the value because they had an interest in the purchase. So that reflects their belief that they own the property. They got a title commitment, and that's where everything came down, because we couldn't get a clean title because the title company couldn't find a clean chain. That's why there's a quiet title action. And back to where I began, we named 40 people based on the litigation guarantee. And so that brought us to where we are today. So I'm asserting, Your Honor, first of all, my folks have inhabited, if that's the right word, used this ditch for 125 years. No one has ever claimed any other interest in it. The 40 folks in this case have not claimed an interest in it, with the exception of Mr. Williams, who provided no proof, and the court said no. So that's the scenario. Now, there's been argument about adverse possession and that sort of stuff, and I have to deal with that. I had to deal with that in the 101 matter, because the judge said you didn't show that you're adverse to anybody, and that's kind of the Gordian knot, because there was nobody for us to show an interest against. We went forward, but there's nobody to be adverse again. Or to Your Honor's question, no matter what happens, Mr. McGuire's clients have no claim. They won't be injured in any manner, no matter which way the decision goes. They're strangers to the title, and I respectfully disagree with their right to be here today, because I think they lack standing, but I've made my point. I think that's enough, Your Honors. I'm finished. Unless you have any questions of me.
Okay, if you were to prevail in this appeal, we would,
I would affirm the decision, obviously, of the district court, Your Honor.
right,
And I would I would find that whereas Mr. McGuire's clients had standing to be a defendant in the lawsuit by the fact that they were named by us, but they lack substantive standing regarding a quiet title action to assert any claim. And so I respectfully disagree with their participation, and that's my answer to your question. I have not spoken to our counter, but I'll just leave it on the briefs, Your Honor.
you've not spoken what?
I have not spoken regarding the cross appeal, but I'll just leave it to the briefs. Thank you.
Counsel. I think you have 28 seconds, counsel. Now, when you see the numbers start going upwards, it means you're out of time.
Okay, I promise, I stopped. Two things. The Barnes case did not involve any issue about whether it was a fee versus an easement. It didn't matter, and that statement was dicta, and the clause or the conveyance was not even reproduced in the opinion. And we've been focusing during my first argument on color of title, but really there's equal focus should be on claim of title. They didn't do anything to claim title. They didn't actually possess under how, as that term has been interpreted in Colorado law.
Counsel, your time has expired, but I have one last question. Do you agree that the trial court ruled that Mr. McWilliams does not have any ownership interest in the land?
I can't disagree with that. I can't recall a specific ruling. It's possible, I just don't recall that.
Okay, thank you.
thanks.
Thank you, counsel, for your arguments. The case will stand submitted and opinion will issue in due course. Thank you both very much.
Your Honor, did you want the case sites, the transcript site, or I gave that to you? When you were asking
You said
what-
page 377.
Yes.
Okay, thank you. Thank you both very much for your arguments.
Thank you.
This is quite the building.
Yes, it is.
I had not been in it before. I've been to the other building many times.
Counsel, when you're ready, you may begin the argument in Garrett versus Credit Bureau of Carbon County.
I saw in the instructions that there's a toggle switch at the,
There should be a toggle switch on either the top or side. In the front. Perfect.
thank you. May it please the court, counsel. My name's Alan Friedberg, 6042. I represent the appellant in this case, Deborah Garrett, who's here in the courtroom. With me at counsel table is Gary Merenstein, number 19163. This case involves two collection letters sent by Credit Bureau of Carbon County, doing business as Collection Center, Inc., and I'll refer to it as CCI, to Ms. Garrett. The first was dated July 12, 2016. The second was dated August 1, 2016. Ms. Garrett contends that the letters violated the Colorado Fair Debt Collection Practices Act and also the Federal Fair Debt Collection Practices Act.
Is that a claim before the court, whether it violated the Federal Fair Debt Collection Practices Act? I thought this was a state statute-focused case.
It is, Your Honor, and the only reason I mention that is because it's clear from the flood case and other controlling law that cases interpreting the federal act apply to the state act.
They don't apply. They may be persuasive
They're-
guidance.
Exactly.
Oh, thank you.
And as the lower court found, the trial court found, there are cases from all over the country interpreting both state and federal acts. The trial court wrote in its footnote 1 that the court's research into federal law involving the FDCPA has revealed at least as many cases and opinions about the interpretation of the duties imposed on collection agencies and the right of consumers as there are panels of all the circuits combined, plus all of the federal district court judges. And I mention that because both sides can find cases with language that support its positions. What we have here is a controlling case in Colorado, flood against Mercantile Adjustment Bureau. And I believe all parties, both parties and the judge have addressed the issues in this case based on the flood case. And it's the flood case that provides not only guidance, but controls here. The statute, both the federal and state statutes, require a number of disclosures, and I won't go through each of those because we've briefed them. The Flood opinion cited numerous cases which essentially boil the issue down to this. If the validation notice contains the disclosures required by the statute, but also contains contradictory or confusing language or conveys a scenario in which an unsophisticated consumer would be confused about her rights under the statute, it violates the act. Our position is that the first letter violated the statute in the following respects. And although the required validation and verification disclosures were contained on the back page of the letter with a statement on the front, and we don't contest this, saying see reverse for important notice, the front of the letter exhorted the consumer to call the collector with an emphasis provided by colored background, a red box outline, priority given to the request to call at the consumer's earliest convenience, bold and capitalized demand to call the phone number, and instructions that the consumer may pay online or by returning the letter with credit card information. It's our position that
I was just about to say, how does that information contradict the information on the back that you have a right to dispute the validity of this debt within 30 days in writing? How does that contradict or send a confusing message to the unsophisticated consumer?
well, first of all, it's the emphasis, the color, the banner type of it. But what the case law tells us is that it confuses the consumer because it urges a call, giving priority to the urge to call over the written disclosures on the back of the letter, the second page of the letter. And by doing that, it emphasizes the right to call, and it doesn't disclose to the consumer that she will lose her right to dispute the debt unless she writes something within 30 days.
Well, Mr. Freeberg, why isn't enough that on the front of the notice, in bold and in large letters, it says see reverse for important notice?
Well, because again, it's the structure of the letter that confuses or may confuse the least sophisticated consumer. And it's important to note that in the flood case, the Supreme Court of Colorado says it's okay to ask the consumer to call, but if you do, then you must add a disclosure saying that this doesn't relieve you of the obligation to put your dispute in writing.
So are you saying that if you put a phone number on the notice, that the content of the advisement that's required is not sufficient? You have to add something to that in order to then counter the fact that there's a phone number on here, which I think people would probably interpret as suggesting or giving people an opportunity to call?
Well, it's exactly what we're saying. That when a collector, instead of just putting down the required language in a collection letter, tries to jazz it up and to convince the consumer to call first, the flood case has said that not only must the collector prominently feature the required disclosures, but it must, and it uses the word must, also prominently inform the consumer that she will lose her right to documentation, verifying the amount of the debt, and that she actually owes it if she doesn't dispute it in writing. So, and I'll skip for a moment to the cases that the appellee, CCI, submitted as supplemental disclosures. If you look at those cases, they involve collection letters in which the disclosures are on the first page. They're in the same font, same size, no coloring added to the urge to call. And in some cases, they're bolded and come before the, if you have any questions, call us, or please call us language. And so really the lesson of flood is that if you're going to add non-required language, then you must prominently feature the required disclosures and prominently inform the consumer that she'll lose her right if she doesn't put it in writing.
So putting the bolded information within that colored area to direct attention to the advisement, which is actually on the back, you believe under flood is not sufficient? You would have to actually move the advisement to the front?
I'm not saying you have
I'm not
to,
exactly sure how you would further alert the consumer.
Judge Ashby, we're not saying that.
Okay.
The statute clearly, both federal and state statutes, say that you can put it on the back, and if you do so, you have to put something on the front saying, please see the reverse side for important information. The collector in this case did that. But the bold and the color and the outlining on the front of both letters draws attention and makes that part more prominent than even the see reverse side. And if you look at the reverse side, there's no bold. A number of the disclosures, required disclosures, are put together in one paragraph and in unbolded, kind of boilerplate-looking language. And I want to quote from the flood case as follows. It says, our decision today does not prohibit or penalize a collection agency from inviting oral communication or making a settlement offer. We're not contending otherwise. It's okay to invite a phone call. But it says, however, when these invitations are made, the collection agency, and again, I emphasize must, prominently alert the consumer of his or her right to documentation verifying the amount of the debt and that the consumer actually owes the debt. And then the word "and," that the consumer must make a written request for verification within 30 days of receiving the communication or else lose this right.
Let me ask you this, counsel. Why is that not effectuated by language in bold in the framed part of the notice that says "see reverse" and "see reverse" capital letters, "see reverse side for important information"?
Well,
Why is that not satisfied?
In addition to our argument about the prominence and the difference between the colored and outlined and bolded portion, the Supreme Court said, if you do that, you also must tell the consumer in your letter that she may lose the right unless she puts it in writing. And
Did the Supreme Court address specifically the "see reverse side for important information" issue? Did it address that in flood?
I don't recall that it did because it wasn't an issue in the flood case. And again, we're not saying that it's wrong to do that, but we're saying if you do that, you've got to add this language. And the trial court in this case said, well, the Supreme Court can't add statutory language. It can't graft another statutory requirement onto the existing statute. And the response to that is the Supreme Court didn't do that. The Supreme Court said if you precede the written disclosures by a request to call, then you must add this language. I see that I have about 3.5 minutes left, but I want to address the second letter. Because the second letter, and we've got case law cited in our brief, can be seen to confuse the rights expounded in the first letter. And in this case, the The larger, bold, capital type saying, "We cannot help you unless you call," sent within the 30-day period that the consumer has to send in its written dispute, it just compounds the problem of the first letter. What it suggests is, first of all, we're going to help you. It suggests that if you want to resolve this, you better call. It says, please call without further delay, totally overshadowing and confusing the required disclosures. And in the mind of a least sophisticated consumer, it tells a consumer, you better call us to resolve this rather than write to say that you dispute. And if you call, we'll help you. So really the second letter actually makes the problem worse as far as the consumer is concerned. There were obviously a number of issues addressed in the briefs, but the other one I want to talk about just briefly is the standard that was applied by the trial court. The trial court used a standard from the Chu-Wei case, which he acknowledged, the trial court acknowledged, was a higher bar than the standard of the least sophisticated consumer used in the flood case, and basically disagreed with cases that provide a more lenient standard. The flood case, and virtually every other case interpreting either the state or the federal act, says that it's to be broadly construed, liberally construed in favor of the consumer. And clearly what the trial court did in this case was construe it narrowly. And what we're asking for in this case is that this court find, in its capacity reviewing the decision de novo, that these letters did violate the Fair Debt Collection Practices Act, and remand the case to the trial court to issue an order in connection or in compliance with this court's findings, and to award attorney's fees and damages. Attorney's fees not only for the trial, but also for the appeal.
Counsel, I have one question before you sit down, and that is kind of like, in the federal circuits, it appears that most federal circuits view these two standards, least sophisticated consumer or debtor and unsophisticated but reasonable debtor or consumer, as being virtually the same. There are a couple courts that say there are some differences, but many of them suggest they're virtually the same, because the least sophisticated consumer would seem to drop you to the bottom rung of a consumer that may not be able to read or understand language or things like that.
I think that's
What's your comment on the use of those alternative tests or alternative articulations of a test?
well, nobody argues that it has to be the least sophisticated in the whole world, somebody who can't read, who isn't mentally competent, that sort of thing. I think the difference is that the Chu-Wei case says least sophisticated consumer is measured by a significant fraction of consumers, and the other cases say just some consumers. And the problem with the Chu-Wei case is that it really calls for an evidentiary hearing. You got to maybe do a survey to show that a significant fraction is less sophisticated. So in this case, Judge Wheeler did set a higher bar and criticized what we believe is the majority of opinions.
Thank you, counsel. Thank you for your answer on that question.
May it please the court, I'm Jeff Logue, attorney registration number 44465. I represent Credit Bureau of Carbon County, commonly, or doing business as Collection Center Inc., and that's what we will call them as CCI. At the table with me is my partner Rocky Edmonds, bar number 46921.
Is that a Wyoming corporation?
It is a Wyoming corporation doing business as well as in Colorado as well.
Okay,
They have an
thank you.
office in Loveland as well. I'm gonna start first by talking about what you were just talking about, the least sophisticated consumer standard. The least sophisticated consumer standard that consumers would want to apply in any of these cases is a person that will pretty much read anything into anything. But that's not what the case law tells us. What you were asking was, what does the case law tell us about that person? It doesn't tell us much. It tells us least sophisticated consumer. They can read. They're still sophisticated. They're just not very sophisticated, okay? But some of the things the courts have told us in some of these cases is that they will read the whole notice. They'll follow directions. They will understand the notice for the plain meaning of the writing on the piece of paper. And I bring that up because in the reply in this case, there's a whole bunch of implicit this, implicit that. A whole bunch of, if you read this and then you read that, a least sophisticated consumer could imply that it would mean this very convoluted thing. That's not what the least sophisticated consumer does. The least sophisticated consumer standard reads the lines on the paper and understands them for what they mean.
So can I ask you a question
Yes,
related
Your
to
Honor,
that
yes,
then?
absolutely.
So if we're talking about the August 1st notice, the trial court didn't address it, but it was something that troubles me a little bit. The bolded language that says, "We cannot help you unless you call," that seems to be somewhat analogous to, in the flood case, they're talking about how personal a letter they seem to be drafting with the signature J dial and leading the consumer to believe that the credit or collection agency is on their side. What's your defense, I guess?
I believe the
putting that in there
differentiation-
and what the point is of putting that.
I
in
believe the
there.
differentiation between flood case and our notice here is the flood case is from a person. It's like, hey, buddy, give me a call. If you dispute this, if you want to talk about this, if you have any issues with this, or we can talk about getting it taken care of. There's a lot more options. It's more, hey, buddy, oh, pal, I'm here to fix any of this stuff for you, or I'm here if you don't agree with this. This, "we cannot help you unless you call," is just an invitation to call to tell them, hey, we know that you haven't been able to pay this bill. If you call us, we can help you with that. It's an invitation to the consumer to call to then be helped by the collection agency to be able to resolve the debt.
We are not computers. We are people, aren't they? We cannot help you unless you call. We are people. The word "we"
Right.
conveys people. When, I'm not sure the distinction in flood and this particular language depends upon what was a person in flood. It's not a person here. It seems to me as like, well, actually, it's being distributed, it's coming from people.
People. And I understand that. I guess the biggest difference then would be that this is, we can help you if you call. People can help you if you call. If you call, you can talk to somebody. We can get a payment plan set up. We can figure this out, kind of thing. It's an invitation to call and discuss getting it taken care of, resolving the debt, okay? Not contesting the debt, not disputing the debt, to resolve the debt. And that was the biggest difference in flood. In flood, the invitation for the phone call or the asking to call was all about everything. You can call me for any reason. Here's my number, give me a call, J dial, give us a call. We will talk to you about if you disagree, if you want paperwork, if you want proof, if you want to talk about anything, we can talk about it. And that is the biggest difference. And this is just saying, hey, we can't help you if you don't call us. If you give us a call, let's talk about resolving the debt. Still doesn't talk anything about disputing the debt. Totally different issue. If you want to dispute it, look on the back of notice 1. It tells you how to dispute it, if you would disagree with it.
Well, Mr. Logue, let me just challenge you on that a little bit. What it says on the second notice is, we cannot help you unless you call, which doesn't sound like an invitation. It sounds like the only way you can get a remedy is if you call us.
Well, reading these two together, I mean, obviously, to get a remedy, I guess that would be the word that I hear in that I would probably not impute to this that much. Because, I mean, it is a, hey, if we talk, we can get it resolved. Okay? The only other way to resolve it is pay it. I mean, that's in the first sentence of the first notice. Pay it, it's resolved. But they can't, I mean, I don't think that there's a real argument with dealing with people that if you're not calling to resolve it, I don't know how else you would resolve it other than pay it. It gives an option. And I think that's kind of the theme of both of these notices together is, here are your options. And I think we all like options.
The second notice didn't relate back to the warnings in the first notice, did it? Did it say, don't forget to keep in mind the things from the first notice?
No, it did not directly. But I do believe, and there is case law, like in Jenkins' case that we cite in our response brief or our answer brief, that states that the second notice can be looked at as an invitation to call, but it also can be looked at as a reminder to that person of their rights. Reminder of, hey, don't forget about this. Don't sleep on your rights. You've got 30 days. So it doesn't overshadow those rights. It more says, hey, don't forget. Don't put that in a pile over here and forget it.
What in the second notice was a reminder of those rights?
It's not a reminder of those rights because we're not overshadowing those rights or trying to even talk about those rights in the second notice, which we're not required to anyway. But we're just saying, hey, don't forget about that debt. Don't forget about that first notice.
Yeah.
And if you want to call, give us a call.
What?
It's an invitation.
What in the second notice says, don't forget about that first notice?
The past due obligation is still unpaid. So that refers to this entire notice, this entire unpaid obligation. It's saying,
It references the obligation part of the first notice. Doesn't reference anything like, oh, by the way, you still have the right to dispute or anything like that.
well, and I don't disagree with that. I don't disagree with that, but I don't think that's a requirement by the law as well. It's only in the first communication, 5 days after the first communication, or in the first communication, you need to give that 30-day validation notice. There's nothing overshadowing it. There's nothing talking about disputing the debt, or if you dispute, call, anything like that. Everything is just, hey, it's an invitation. Give us a call. We can talk to you about this. We can help you resolve this. Again, that goes back to my options idea. You, as a least sophisticated consumer reading this notice, one, to be clear, everything's in the box. Everything's in the color. Nothing's more prominent than black on white. That's why everything that we turn over to you is black on white. So when it's said that it's not prominent enough, it's boilerplate language, it's on the back of the notice, it's not prominent enough. This is one of the biggest things on the front. They want to say, oh, your I is to call. The I goes right to call. It's the same as C reverse important notice. So if it's going to go to one, it's going to go to the other. And the least sophisticated consumer will read the back of the notice. It's on the back by itself. This is the law. This is all the legal stuff that is required. There's nothing linking this to the back. It's not saying, oh, but don't worry about that back. No, it's saying, look at the back, read the back, make sure you do the back.
Let me ask you this. Some of the cases talk about, in trying to determine whether or not it's understandable to the least sophisticated consumer, you look and see whether it's subject to being interpreted in two reasonable ways, one of which would be inaccurate. Is it subject to being interpreted, we cannot help you unless you call? Is it subject to being interpreted as kind of like, call us to dispute your debt as well?
I would argue that it doesn't. Because when we're talking about helping, do something, it's to resolve it. It's to resolve that debt. Helping is not disputing. There's disputing the debt, there's paying the debt, there's resolving the debt. Resolving and disputing, that's what the underlying court in this case said, that those are two different things. And in our notices, it says, or in my client's notices, it says, if you pay in full, this will stop. So option one, pay. Okay, option two, I can call them. Option 3, I can fill out this form and send it in or pay online. Oh, I need to see the back. I turn it over. I can do the writing. Actually, there's another writing in the middle here for the cease and desist communication. But it's telling you how do I, if you want to stop it, you pay it. If you want to ask for more information, you dispute it in writing. If you don't want them to contact you anymore, how do I do that? Writing. If I want to talk to them about it, I call. It's giving you the options of what you can do. None of these options are saying, do this, but don't do that. Or, oh, you can do this by doing this. You can dispute by calling. That's what most of the cases that are presented by Garrett say. It's a lot of cases, immediate, strongly recommend you call us. If you have any issues with this debt, just give us a call. That's not what this is saying. This is saying you have the option to call, you have the option to pay, you have the option to dispute. You have the option to tell us never to contact you again except in writing. Then you get the second notice, and the second notice just says, hey, we still show that this is unpaid, give us a call. That's all it's saying. It's not saying give us a call to dispute, or hey, you might not feel like you owe this anymore.
It's not saying give us a call to dispute, but could a reasonable consumer, an unsophisticated but reasonable consumer, construe it to give us a call to dispute? We cannot help you unless you call. If you're thinking you want to dispute either the debt or the amount, could an unsophisticated consumer look at that as saying this encompasses disputing the debt?
And again, I would say no, because I would say that talking about helping you and disputing the debt are opposites. Helping, resolving, taking care of this debt is one thing.
Well, one way to take care of it is to dispute it and get rid of it altogether, right?
Well, if you dispute a debt, all the dispute's doing is stopping it until it can be verified.
Well, but if the consumer believes that the debt is illegitimate, then disputing it may be what for them is helpful.
That would be a very case-specific point, but at the same time, if you do dispute the debt, then you would go back to the original law, and how do I say I don't owe this? Helping you would imply we're actually going to help you with something. Disputing it would be, I don't agree with this, show me. Show me. This is, I guess the biggest difference is help is more of a cordial, let's work this out together, and disputing is you think I'm lying.
Well,
You think I'm not being truthful to you.
Mr. Loke, we're going back and forth, and what does help mean? And so is that confusing, and therefore would it be overshadowing?
I don't think so, and I think that the amount of reading into what help means, other than just looking at, hey, I can get help by calling them, is linking that help. If we are reading it way deeper than a least sophisticated consumer would. The sophisticated consumer would say, okay, to help, yeah, okay. I can call them if I want help. But I don't believe that the least sophisticated consumer is going to say help is the same thing as disputing it. By disputing it, you're saying, I am in conflict with you, is disputing. Helping, we're not in conflict. We are talking on the phone to try to get this resolved.
And let me ask you that, does that convey a false sense of we're on the same side versus kind of like, no, I'm actually an agent for a third party trying to collect a debt?
I still believe that it's still, because of reading the letter as a whole, the letter is from a collection agency, the letter is saying that this is past due, the letter is saying you need to pay this, that read in conjunction with the entire letter, just by saying we can help you, we cannot help you if you don't call, that's not taking it out of, that's not putting it in a friendly manner, that's just saying, if you don't call us, we can't do anything. We can't do anything. We can't help you resolve this case or resolve this account. I guess it's not a case. Resolve this account. We can't do that unless you call us. And I believe that that's true. I believe that what they're telling them is the truth. Because the only other way to resolve it is to pay it, or they can dispute it and get more information about it and then worry about that. But I don't believe that just saying, hey, we can help you, or we cannot help you without you calling us, is, one, overshadowing anything with the 30-day validation. And I don't think that it's putting out there enough to where it's saying, hey, you're my buddy, you're my pal, I can help you with anything. It's saying, we can't help you unless you call, and it's saying to pay this debt. Other than that, Your Honor, I mean, I believe least sophisticated consumer standard is there.
Do you believe that this is a question of law that we reviewed de novo?
I believe it would be, Your Honor. Yeah, I mean, that's what we said in the underlying court case as well, is that the fact is, here's what the notice is. It's either violating or not. I do believe that the flood case has good law in it, but I don't believe that it's on point with this case, because I think that the differentiation between that case and this case's notice is enough to where you can't say A plus B equals C. I think they're a difference enough.
Thank you, counsel, for your
Thank you, Your
argument.
Honor.
You have 13 seconds, counsel. You want to use it? He doesn't. I thought you said he did.
No, that was his, he added 13 seconds to
You have no seconds, counsel. You cannot use it. I want to thank counsel for their arguments in this case. They were excellent arguments. They're going to help us, come up with an opinion in the case. Thank you both very much for your arguments. The case will stand submitted. Opinion will issue in due course. Thank you both. Thank you very much.
I'm good.
Counsel, here in the case of people in the interest of MV,
Yes, Your Honor. David Miliaccio, representing Mother MM.
Yes, Your Honor. Kevin Webster, representing the El Paso County Department of Human Services.
okay, this is our 2:30 docket. You probably weren't here when I asked some questions earlier. When you came in, did you receive, or did you get from the bailiff's desk some oral argument procedures, written instructions on our oral argument procedures?
I believe I received it online, Your Honor.
Well, that's even better.
Same goes for you, Your Honor.
Okay, you had a chance to read those?
Yes, Your Honor.
Any questions about them?
No, Your Honor.
Okay, remember, we're live streaming and our arguments. The arguments will be archived on our state website. Don't mention the names of minors or any sex assault victims or any confidential or sensitive information. When you come to the podium, please give us your name and attorney registration number. And for anyone who came into the courtroom since our introduction, please turn off your cell phones and pagers so as not to interrupt the oral arguments. With that, I think we can begin.
May it please the court. I'm David Miliaccio, number 8404, representing Mother MM in this case. I'm supposed to start strong in these matters, but I have to start with an apology to the court because I raised a personal jurisdiction argument for the first time in the reply brief. And I just have to say, after reading hundreds of cases and regulations that talked about jurisdiction in the ether without mentioning it, it occurred to me nobody had talked about personal jurisdiction, and I thought it applied. My request would be, in fairness to counsel, that counsel be permitted a supplemental briefing if the court is interested. With that, I'd like to move on to jurisdiction. The ICWA is a jurisdictional statute. The Holyfield case says that 1911B creates concurrent but presumptively tribal jurisdiction in the case of children as these who are not domiciled on the reservation. So it talks about tribal jurisdiction over Indian child custody proceedings. The regulations recognize that jurisdiction is concurrent between the state and the tribal courts. And the final rule, and this is out of the preamble, clarifies the requirement that a state court determine whether the state or the tribe has jurisdiction. So there's no question that tribal jurisdiction is involved here. And the statute itself requires the BIA to issue the regulations, which it has done, to establish procedures through which the tribe can assert jurisdiction over the proceedings and over the child. It's interesting, a policy argument that comes up is that the regulations note that conflicting state statutory interpretation can lead to arbitrary outcomes and threatens the rights, that is, the rights of the tribe and the rights of the child, the statute was intended to protect. And I'd like to note at this moment that the ICWA is a best interest statute. It is clear from the regulations and from the case law that the ICWA intends that it is in the best interests of an Indian child that the tribe have a say in the outcome for that child. Now, does the state court have subject matter jurisdiction over a dependency and neglect? Of course it does. But that changes, whereas here the court has reason to know it is dealing with an Indian child. Now, all of a sudden, that jurisdiction is, I don't want to say compromised, but that jurisdiction changes in some way. Because where there's reason to know you have an Indian child, the tribe can come in and take jurisdiction. But first, of course, the tribe has to determine whether a child is an Indian child, and that's in the purview of the tribe. However, the tribe can't say anything unless it has notice. And that's why the ICWA says the tribe must have prior notice of any proceeding that might involve, for example, foster care for an Indian child. So a state court with reason to know it has an Indian child cannot proceed unless and until notice is given.
But Mr. Miliaccio, so practically speaking then, what's supposed to happen if you have the state court proceeding moving forward and you are resolving the issue of ICWA, getting information so that you can decide if you have a reason to know, then sending out notices, then waiting for responses? Are you saying as soon as the parent stands up and says, my mother said we have Navajo heritage, that the state court cannot act until the point in time where ICWA has actually, whether it's been determined that this is or is not an Indian child?
Well, it's a complicated question, but I think we need to look at the facts of this case. If we look at Mother's ICWA 1 affidavit, which appears in the record at page 29, we see that Mother provided lots of specific information as to the children. We know the names of the children, we know their birth dates, we know where they were born, we have the identity of a tribe, and Mother later provided another tribe, which was Apache. We have the names and contact information for aunts. We have the name of and the birth date up to at least the year of the maternal grandmother.
But my question is,
Yes.
given that, are
Yes.
you saying that once she provides that information, the state court no longer has jurisdiction unless it then ultimately determines that the child is not an Indian child?
No.
Okay.
I'm saying that in this case, at the beginning of the case on August 3rd, 2017, Mother fills out her ICWA affidavit. Now we have an emergency proceeding and the children are placed in foster care. Well, okay, that's fine and that's appropriate because it's an emergency proceeding and the court really doesn't have reason to know quite yet. But once the court has that ICWA affidavit, now ICWA is triggered. And so now you don't schedule further proceedings without giving the tribe notice. And specifically, we're talking about adjudication. And and by the way, does that mean you hang things up forever? No, because the ICWA says you give prior notice, which means you have to give notice to the tribe and no proceeding may be held unless it is 10 days after the tribe has received notice. That's 10 days. And the tribe has 20 days, if it asks for it, to prepare for the hearing.
Well,
So-
Mr. Miliaccio, why isn't that just a procedural requirement and not a declaration of jurisdiction?
Because at that point, you have reason to know. At that point, the court has reason to know. And that means that it may very well be dealing with an Indian child. If it can't know that it's dealing with an Indian child until the tribe comes in and says so, and then the tribe can't do that until it has notice. But at the same time, now you have notice. Now the court's on notice that this child may be declared an Indian child and that the tribe may come in and exercise its jurisdiction. So it's not merely procedural, it's really jurisdictional.
Do you agree that most of the courts who have addressed the issue, though, don't agree with that?
I don't think that most of the courts don't agree with it. I mean, there are some that do and some that don't. The South Dakota courts obviously say it is jurisdictional. And again, they say it's jurisdictional. We don't know whether it's personal or subject matter, but assuming that it's subject matter, I think that there's a split of authority on that. But the question becomes, in the best interest of the child, looking at narrowly at that focus, is it in the best interest of the child for the trial court to simply proceed once it has reason to know the child may be an Indian child? Is it in the best interest of the child for the proceeding to go on and maybe proceed to termination?
Doesn't the regulations actually suggest that you can go on once you have reason to know? Because they say once you have reason to know that the child could be an Indian, you must presume, an Indian child, you must presume that the child is an Indian child and conduct your proceedings accordingly.
Correct.
And conduct your proceedings accordingly.
Correct.
In other words, you still are conducting proceedings, so that suggests you have jurisdiction to conduct those proceedings.
As long as you conduct those proceedings within the strictures of the ICWA, which require a higher standard of proof, which require foster care for a qualified expert
Why aren't
testimony.
those just erroneous rulings of law, as opposed to, oh, I forgot to apply the higher standard of proof, that deprives me of jurisdiction?
Yes, because, and this gets back to my personal jurisdictional argument, that the interesting thing is if you read Rule 19, Rule 19 applies to the tribes in these cases because the tribe is absent, it can't protect its interest and so on. So I still, here I guess is the bottom line. We contend it is jurisdictional. But even if it isn't, failure to conduct proceedings in accordance with the ICWA requires reversal. And I say reversal, not remand. If the court chooses to reverse because it's an error of law, that's all right too. The problem being the ICWA in and of itself requires prior notice. It isn't enough to send it back to the trial court and say, we're going to tell the tribe what's been going on for the last year. And here we are, we've maybe had an APR, and maybe we've had an adjudication, maybe we have a motion to terminate on the table. By the way, tribe, are you interested in coming in? Well, the tribes don't have, most of them are not laden with money. Some have some, but most of them are not. And are they going to be interested in coming in and blowing up a 2-year placement? No. The tribes do care about their children, and even if it is one of the tribe's children, don't think the tribe really thinks that's in the child's best interest.
Counsel, can I switch you to your other issue in this case, and the erroneous or alleged erroneous admission of the videos in this case?
Sure.
Let me ask you this. If we were to agree with you, why would that not be harmless error? Why would that be prejudicial error requiring at least a new proceeding? Why would mother have been prejudiced in light of essentially independent grounds upon which there was quite a bit of proof for finding the child dependent and neglected?
Well, our argument is that those videos were the primary evidence against mother. I mean, there were snippets of those videos attached to the petition. And it's obviously a judgment call, but it appears to me that without those videos, if you take those videos away, you don't have enough evidence to adjudicate.
What about the domestic violence allegations? What about all the proof that was indicating about the chaotic environment in which the child was and the volatile relationship between the mother and, I believe, the father?
Well, those are certainly there, but we have to remember this is a jury trial too. And so when the jurors are presented with all this video evidence, we contend that that is really much more prejudicial than probative, and that it's not harmless but very harmful. So with that, if there are no more questions about that, I'd like to just quickly return to the question of whether the ICWA applies at adjudication. I'm aware of the LL case in which Judge Furman wrote that it basically does not, because the ICWA does not mention adjudication. But I'd like to go quickly through the sequence that happens in a case such as this. In fact, happens here. You start with this case with a foster placement. Okay, that's fine, not held under ICWA standards or anything else, but it's an emergency proceeding, and mom now files an ICWA affidavit. So now we go to adjudication, but we get to adjudication, and now the court has reason to know. If the petition is sustained, then the foster care continues, and the court's jurisdiction to order the foster care continues. If the petition, on the other hand, is not sustained, Then the court loses its jurisdiction to order the foster care, and the foster care goes away, along with other restrictions on the family. So we contend that the adjudication is the linchpin for continued foster care, and therefore ICWA does apply at adjudication. So with that, I would like to reserve the balance of my time, if I may, and I think I have 3 minutes left.
I think it's on the right side.
There it is.
We'll
Thank you, Your
figure
Honor.
that out sooner or later.
We should have a sign or something.
Good afternoon. May it please the court. My name is Kevin Webster, attorney registration number 49980, and I am here today on behalf of the El Paso County Department of Human Services. Just briefly, the posture of this case is an appeal from an adjudicatory trial in a dependency and neglect case. Specifically, what is at issue is whether ICWA, the Indian Child Welfare Act, was complied with. Now, as counsel contends, well, I should start off by saying counsel contends that the notice requirement was triggered, and we are not disputing that notice was not sent. There is nothing in the record to suggest that notice was ever sent. I would like to address counsel's jurisdictional argument. However, I believe there's a threshold issue here of whether or not the notice requirement was actually triggered. Now, turning the court's attention to the case of People v. LL, the court must answer two questions affirmatively. Does ICWA apply to this child, and does ICWA apply to this proceeding? Now, in the briefing, we focused heavily on whether ICWA applied to this child, so I would like to touch on that briefly. ICWA applies to a child when the court has reason to know. Now, the regulations do suggest that a court may have reason to know where a parent in a dependency and neglect case asserts Indian heritage on the record. However, those are the federal guidelines, and I would like to direct the court's attention to BH v. People in the interest of XH. In that case, the Supreme Court held that ICWA is triggered by sufficiently reliable information of any criteria. Now, we're not disputing that as a general matter, a parent's assertion of Native American heritage would be enough to constitute reason to know. However, turning to the specific facts of this case, specifically Mother's ICWA affidavit. At the time the petition was filed on August 3rd, 2017, there were 3 children subject to the petition. She filed her ICWA affidavit, and that affidavit was sworn, and it was signed by counsel as well. So she was represented by counsel when she did that. In that affidavit, she claimed Native American heritage as to only 2 of the 3 children. And if the court reviews that affidavit, the affidavit speaks specifically to the child's heritage, not to the parent's heritage. Now, looking at that affidavit, it creates a confusing circumstance, and I contend that it does not create reason to know that this child is a Native American child. Rather, it creates reason to suspect, reason to inquire, and reason to further investigate.
Counsel, can I just jump in with 191126 and reason to believe language under the Colorado statute? How does that figure into your argument?
Well, Judge, it does create a reason to believe. However, under the Colorado law and the case law that has been built upon that, the department has an obligation to send as complete of notice as possible. Send enough information that a tribe could make a determination as to eligibility. So that ties back into the issue with this affidavit. This affidavit claims only heritage for 2 of the 3 children that were subject to the proceeding. Looking at that from a common sense perspective, a mother is claiming Native American heritage for only 2 of her 3 children. The logical guess is that she is claiming heritage on behalf of a father. So at that point in time, the department has an obligation to inquire further, to obtain ICWA affidavits from each of the fathers. And in this case, that is what was done. And every father in this case denied Native American heritage. The issue here is that the department was making efforts to inquire further in order to comply with the notice requirements and to obtain further information from Mother. Mother was court-ordered to complete what's called an ICWA 2 affidavit on several occasions, which would provide additional information. She repeatedly defied that court order and did not provide that information. I would note that a parent also has an obligation to provide information necessary to make an ICWA determination. So based upon that confusing set of circumstances, the department was in a state where it was attempting to inquire, to investigate, and to ultimately comply with the notice provisions. However, at that time, there was insufficient information to comply with the notice provisions. Now, even if this court does find that there was reason to know, the court still has to look at whether the Indian Child Welfare Act applies to this proceeding. Going back to LL, the Court of Appeals specifically stated in that case that an adjudicatory trial is not a child custody proceeding. Now, counsel for the appellant cited in a supplemental authority the case of People v. It was People in the Interest of ER. I would like to direct the court's attention to that because that, at a glance, might suggest that an adjudicatory trial is a proceeding in which ICWA, which is subject to ICWA, I should say. However, that issue is wholly distinguishable from this case. In the case of People in the Interest of ER, there was an appeal from an adjudicatory trial, and what happened in that case was that the trial court never even inquired. There was absolutely no inquiry. Based upon that, the interpretation of that case is that when we ask this question whether or not ICWA applies, it's not necessarily a question of whether ICWA applies, but to what extent it applies. Because the entire body of law created surrounding the Indian Child Welfare Act creates an affirmative obligation to inquire. So in every case, there is a baseline requirement that the department, the court, the parties to the case inquire. Beyond that, it becomes a question to what extent it applies. And I would contend that the notice provisions do not apply to an adjudicatory trial. And that position is supported by the language of the statutes and by the language of the regulations.
Isn't the notice triggered by the information that's received by the parties involved in the case in the court?
Well,
As
Judge,
opposed to the procedural stage?
Your Honor, that's correct that notice is triggered by that, but whether notice is required to move forward with a specific hearing. The statutes state that notice is required for a hearing, a child custody proceeding. There are multiple definitions of a child custody proceeding. The one that's most relevant here is a foster care placement proceeding. Now, regulation and statute defines that as an action removing the child. An adjudicatory trial is not an action removing the child. To say that it is to interject an issue that is not necessarily part of an adjudicatory trial. The adjudicatory trial, the sole issue is whether or not the child is dependent and neglected. Imposing the notice requirement on an adjudicatory trial would essentially be saying that placement is an issue, when in fact, at that stage in the proceeding, nobody is putting placement at issue. That is not an issue that is tendered to the jury. That is not an issue that the court, the judge, will decide at the adjudicatory trial.
So is ICWA applicable to the dispositional hearing then?
I would say under the current case law, specifically People v. ER, it would appear that ICWA is applicable to the dispositional hearing. And
Why wouldn't it be similarly applicable then to the adjudicatory hearing?
well, Your Honor, I would turn to the language of the statute. So the language of the statute specifically states that it applies in a foster care placement hearing.
And does the language of the statute encompass the dispositional hearing as well?
I would say that that would have to depend on a case-by-case basis. In a dispositional hearing, there may be, the placement may be put in issue at the dispositional hearing. That was something that was addressed in the ER. And turning again to ER, that was an issue of inquiry. But I would like to turn to opposing counsel's contention that mere continuation of an emergency placement renders this a foster care placement proceeding. Again, I would submit to the court that in order for it to become a foster care placement hearing, that needs to be put in issue at first. Generally, the Indian Child Welfare Act notice provisions will not apply to an emergency placement hearing. By attempting to equate a continuation of a prior court order to an affirmative court order, it does not add up. the mere fact that the trial court will continue to exercise jurisdiction in itself does not render it a court order for foster care placement. As I see I'm running low on time, I would like to turn briefly to the jurisdictional argument that counsel has made. I did file a supplemental authority, people in the interest of Antoinette S., California Court of Appeals case, which analyzes the NAH case. And I would say to the court, to my knowledge at this point, South Dakota is the only state that I am aware of that adheres to this view that ICWA is a jurisdictional statute and that failure to comply with the notice provision divests the trial court of jurisdiction. Even the state of Iowa, which briefly adopted this view, disavowed it in, I believe it was people in the interest of NNE. They specifically disavowed that view and deviated from that position. I don't believe that's supported by the statute because the statute provides a remedy for noncompliance with the notice provision. And that remedy is not a divestment of jurisdiction. That remedy does not include jurisdiction of the trial court automatically ceasing, the court orders being vacated, the child needing to be returned home to the parents immediately. The remedy is that the party claiming that the notice provision was violated has the ability to petition any court of competent jurisdiction to invalidate the action. So I believe if you look at the statute itself, the view that ICWA is a jurisdictional statute divests in the way that counsel contends that it is not supported by the language of the statute. And I have one more issue that I want to touch back on, going back to the adjudicatory trial. I want the Court of Appeals to consider the consequences of requiring notice to be effectuated prior to holding an adjudicatory trial. In a dependency and neglect case, a jury trial is held on very strict guidelines pursuant to statute. The jury trial needs to be held within 90 days of the request, or in an expedited permanency planning case, within 60 days of the request. The effect of requiring notice to be effectuated and responses to be received before an adjudicatory trial would be held would leave the lower courts and the practitioners in a position where they're constantly trying to determine whether or not to comply with the state statute or with ICWA provisions. There would be many circumstances in which notice has been sent, but no response has been received within the timeline for an adjudicatory trial. And with that, I would yield the remaining time to the guardian ad litem.
No, you're not done yet. Oh, excuse me. Is the guardian ad litem going to address the issue about the admission of the videos?
I had prepared that, but I wasn't planning on that. You can ask the county attorney, I guess, would be the...
Okay, I will ask you then. The same question I asked opposing counsel. I understand your argument that the videos were properly admitted. If you were to assume that it might have been error to admit those videos, why wasn't it prejudicial error?
Well, Your Honor, there were numerous factual allegations in the petition, as well as evidence, as the court previously stated, of domestic violence and other parenting issues which were presented to the jury. I would submit to the court that, notwithstanding the video issue, there was sufficient evidence for a reasonable jury to find that the children were dependent and neglected.
Is sufficiency of evidence the test for determining the harmlessness of evidentiary error?
I apologize, Your Honor. I spent most of my preparation focusing on the ICWA issue.
Okay. Thank you. Thank you, counsel. Wait. Guardian ad litem speaking. Please.
May it please the court, Anna Ulrich, guardian ad litem on appeal 33367. I would like to point out that we do have 4 children who are subject to this appeal. The ages range from a 1.5-year-old to 14.5 years old. Because of the 1.5-year-old's age, this is considered an EPP, at least as far as timeframes are concerned, which is relevant to the issue of adjudication because it had to happen within a certain period of time. I would just follow up very briefly regarding the issue of the videos. By my calculation, between the department and the GAL's arguments at the adjudication hearing, it was well over 10 pages of their arguments were focused on the domestic violence and chaotic living situation that that created for the children, as opposed to the videos and what they symbolized.
What was the length of the transcripts having to do with the videos and what they symbolize?
I don't recall, but I do recall when I compared it, it was much more, and that's what I stated in a footnote in my brief. So, I would like to address the issues of ICWA and notice, just because I have a concern, and I'll have to do it very briefly, about that particular issue as it relates to this case. I do agree, as has been stated, that the two primary questions here are, does ICWA apply to this procedure, and does ICWA apply to this child? Both of those have to be answered yes in order for the appellee's arguments to be adopted, appellants. But I would answer that the proper answer is no to both of those. And I want to point the court to the issue of the Indian child provisions in the regulations. We know from case law that it's a totality of the circumstances standard that the court should be looking at, and it's particularly relevant under 25 CFR 23.107 sub B1, whether the department was exercising due diligence. So the issue of due diligence is in the regulations, the ICWA regulations here. And here we have the department requesting the court ordering the mother to provide more detail through the ICWA 2 form 4 times before the adjudication hearing. Now, that's based upon my count, but I believe it was at least 4 times. And as the county attorney indicated, mother provided confusing and contradictory info. So I would
Counsel?
just say.
Counsel, your time has expired.
Thank you.
Thank you very much.
Well, here we are. How many years post BH? 12 years. And we still are dancing on the head of a pin over what triggers the notice requirement for ICWA. BH says that in light of the purpose of the act, the threshold requirement for notice was clearly not intended to be high. Notice requirements are not to be narrowly construed, but rather must be given a broad reading. So, for example, in the J.O. case, Judge Daly, you wrote that father's advisement that he was 1/4 Apache and his belief that he was entitled to enroll in an Apache tribe was reliable enough to trigger the notice requirement. As to the question of whether the ICWA applies to an adjudication, the ER case says that ICWA applies when an Indian child is subject to a custody proceeding or emergency proceeding. A child custody proceeding includes any action, this is citing the regulations, other than an emergency proceeding that could result in foster care placement. So, here we have the department, again, trying to lay it off on mother. Sure, mother has the obligation to cooperate. It is not mother's job to do the county's work for it. Here, the county knew the basics that it needed to know. It knew who the children were. It knew who the tribes were. It had mother's statement that the children were eligible to enroll in the tribe. That's enough. And as for the time factor, well, what's the problem? August 3rd, at the very beginning, mother files the ICWA affidavit, right? Mother files the ICWA affidavit. So now the county is saying, well, how can we possibly hold an adjudication when we have to do it within 90 days? August 3rd. Court turns to the county attorney and says, go thou and give notice to the Lakota Sioux. And by the way, talk to mother on the way out and see if there are any other tribes that we need to give notice to. It's not that hard for the county to do it. They have it in their computer. Simply go back, give it to your ICWA person. The ICWA person spits out the notice with all the information that we have, and it goes to the tribes. Adjudication hasn't even been scheduled yet, but they can send the petition, and now the tribe knows about the action. The infinite notice isn't required. 10 days, says ICWA. You can hold your proceeding 10 days after the tribe has received notice. In the interest of care, you might want to do it 30 days later because the tribe has 20 days under the ICWA to prepare for the proceeding if it asks for it. But after 30 days, if the tribe has not responded, you can go ahead and have your proceeding. And I think that that's pretty clear under ICWA. Let's not lay all this off on mother. Mother did not provide all the information the county wanted. The county still had enough information to have to give notice. BH, not a high bar. Thank you for your time and attention.
Thank you, counsel. Thank you all, counsel, for your arguments in this case. The case will stand submitted. Opinion will issue in due course. That concludes the court's business for this afternoon. Court will stand in recess, and the bailiff will so announce.